The first thing I'm going to go to, and this was Richard Michael Blackwell, which is English bulldog. They took an outrageous liberty with him, and I'm going to explain part of this case. It took quite a bit of research. You won't get this with a solicitor. Solicitors are lazy, they don't necessarily know the law, and they haven't got your best interests at heart. They are associated with the Solicitors Society, and they can have their ticket pulled at any time. So can a barrister, etc. But there are processes in place that allow people like myself to go through the law, to look at your case, to read through your documents, and to create a case stated and present to the court. Now, the court won't allow me to speak. I think we need to get that changed, because they have a legal monopoly which technically is unlawful under the European Court of Human Rights and our ancient laws and customs. If you go back to the common law, you can use anyone in your defence, including yourself. So I'm just going to explain to you what happened. Don't forget the case was thrown out against him yesterday. I'm just going to show you why. And that's because the case stated in his defence, the arrest was unlawful, unnecessary and disproportionate. Points of law, page 5, paragraph 9 and 10. Not guilty. So if it went any further, he's doing a not guilty plea, and then it goes through other defences. No admission of guilt whatsoever. Blackwell vehemently denies the offence's charge and uses previous High Court rulings in his case-stated defence. The primary case law: A. Harvey versus Director of Public Prosecutions, 2011. Williams, on application of Merthyr Tydfil, Crown Court, 28th, and that was in 2016, Queen's Bench Division. And Scotto versus Crown Prosecution Service, and there's more. So they're the three primary cases about exactly what we're talking about in the offence. Section 5 defence. It is defence for the accused to prove that he had no reason to believe that there was any person within hearing or sight who was likely to be caused harassment, alarm or distress. So the emphasis to everyone out there at the moment watching this: it is not illegal to swear in public. It's not illegal to tell someone to fuck off. It's not illegal to call someone a dickhead in public. What the offence is causing harassment, alarm and distress. And now one part of this might make you jump. There is a difference between saying fuck off and saying fuck off. Do you understand? Tone, mannerisms, everything can count to causing harassment, alarm and distress. The point is, their own evidence showed that no one was caused harassment, alarm and distress, and High Court's already said a police officer can't be caused harassment, alarm and distress just by using the word fuck off. That his conduct was reasonable, right? So there's a defence there. Blackwell used common language. There was no intent to cause harassment, alarm or distress. Blackwell's conduct was reasonable in the circumstances. For a person to be found guilty of a criminal offence, he or she must have committed an illegal act, the actus re. Swearing is not illegal, and had the required state of mind, i.e. the intention, or mens rea, for the criminal offence. In this case, there is no intention to cause the public alarm, harassment or distress. As the language was not directed at the public, it is common use. It was directed reasonably at the police officers because of their interference with English Bulldog's rights. Common use language does not cause harassment, alarm and distress unless there could be an identified group with a particular disposition, such as nuns. In fact, the public was in support of the protest and I could not see any nuns. I used common use language towards the police reasonably, and the police are not nuns. The facts of this case are simple. On the 8th of the 7th, 2023, a protest, otherwise known as a petition, which is making a demand, a right, 1688 dictionary, rally was being held in Lincoln to highlight the public's discontent, dissent, abhorrence towards illegal immigration. And the protesters were showing that they believe the illegal immigration and intentional abuse of process, which because of the intent becomes a criminal offence, perverting the course of justice, and which carries a life sentence, and the protesters find that repugnant. Blackwell and the protesters find the undocumented migrants being located and housed in England to be repugnant because the migrants are being housed ahead of waiting lists for our own inappropriately housed and homeless people. It is well known and documented that organisations are promoting and prompting illegal migrants in Calais, France, to dispose of their documentation and to lie to the British authorities as to their national origin and circumstances of their travel to England. This is, in effect, committing the crime of perverting the course of justice, as immigration and asylum are legal processes. It is a legal requirement in law to report offences. This defence should be taken as a recorded report of the offences by the asylum seekers and the organisations that instruct them to commit the offence of perverting the course of justice. The police and the CPS have maliciously prosecuted English Bulldog. It is a point of law and fact that the police and prosecution should not be biased or consciously or unconsciously biased or a perception of bias. The prosecution states that English Bulldog attended a right-wing protest, referring to right-wing is intended to create bias towards the individual and the protest. The prosecution and the police have politicised the law, enforcement of the law and the courts. The police have arrested Blackwell and the prosecution have prosecuted Blackwell not because he committed an arrestable offence, but because he holds an opinion, an honestly held belief they consider to be right-wing. Freedom of expression in a public place is not a criminal offence and nor is swearing. Using common use expletives, fuck off, meaning get off me or go away. So if you look it up in the English language dictionary, fuck off means get off me or go away. And descriptors like dickhead means idiot. Now, the further on we go with this, you'll find that the description dickhead is probably apt because the police officer had no authority to arrest. That means he was ignorant. That means he's an idiot. Did not and does not cause harassment, alarm or distress in this case. In fact, there are many instances where police have themselves told the public to fuck off. Fuck off or I'll arrest you. And by the way, we've got the video evidence of that. And show me ID or fuck off. That's a police officer talking to a member of the public. If the court wishes, I will offer this evidence as systematic antecedents of police use of the word. Hope you're all enjoying this show, by the way. There is no evidence that English Bulldog caused harassment, alarm or distress to the police or members of the public by using common use expletives and or descriptors. English Bulldog conduct was reasonable in the circumstances explained above, and that means he was saying, hang on a minute, these people are disposing of their identity documents, they're being brought across the channel, they're lying about where they come from, you're housing them, and they're committing a criminal offence of perverting the course of justice. And Care for Calais are advising them to do it, and other lawyers around this country are advising them to dispose of their documents and to lie to the British authorities in a asylum process, a legal process. That means you are perverting the course of justice. Because if you hadn't lied, you wouldn't have been given asylum and you wouldn't be given leave to stay, to remain. Carries a life sentence. That's the sentence for perverting the course of justice, just to let everyone know. Blackwell's conduct was reasonable in the circumstances placed above. Blackwell was being discriminated against for petitioning unlawful acts by the authorities and the illegal immigrants, and the Blackwell was being harassed by the police who are politically biased to his opinion. That was proved because the paperwork, the CPS and the police described him and the protest as far right. That in itself is illegal, just to make sure, without any other elements to it, right? I'm not going to go through, I might go through every point of it. Points of law. It is admitted in a prosecution case that the police acted outside of their powers, they admit to an unlawful arrest by not cautioning Blackwell at the time of the arrest, contrary to the Police Act 1984 Codes of Conduct. That's the first point of law. And they admit in their paperwork that they never cautioned him. And they had to make that admission because they was using video evidence where the whole video evidence shows that he wasn't cautioned. The second is the Public Order Act 1986. Listen to this. UK Public General Acts 1986, Section 64, Part 1, Section 5, 4 and 5 were repealed in 2005. A. The Serious Organised Crime and Police Act 2005, UK Public General Acts 2005, Section 15, Schedule 7, Part 1, Public Order Act 1986. That is the act in which, paragraph 26, that's the act in which we're talking about. The Public Order Act 90 is amended as follows. In Section 5, harassment, alarm, and Section 5 that he's been arrested for, harassment, alarm or distress, omit subsections 4 and 5. This was an arrestable offence without warrant until this act was passed into law in 2006. The authority for an arrest for this offence was repealed in 2006. The following was repealed. A constable may arrest a person without warrant if he engages in offensive conduct which the constable warns him to stop, and B, he engages in further offensive conduct immediately or shortly after the warning. To be clear, this was an arrestable offence without warrant until 2006. It was repealed, meaning it was not an arrestable offence after 2006. Meaning it was a summons-only offence. The officer in this case were authorised in law to issue a summons. They were not authorised to arrest with or without without warning, unless I refused to give my name and address. They did not ask for my name and address. This is important. People listening to this. When the old bill asks you for your name and address, the law says if you don't give it, or they suspect that you have given them a wrong name and address, they can arrest you. But they have to be pretty strong, and you've got to be pretty strong to turn around and say, well, hang on a minute, why aren't you believing my name and address? I've just given you my name and address. Give them your name and address, because they write you out summons, and they give it to you. Most of them, they couldn't be asked. But in this case, that's all they had authority to do. Nothing else. Instead, they arrested him, physically put handcuffs on him, kept him in custody for 48 hours, and also caused pain and suffering, because if you watch the arrest, you'll see what they did to him, right? They also caused pain and suffering during the 48 hours he was detained unlawfully. They were not authorised to arrest with or without warning unless I refused to give my name and address. They did not ask for my name and address prior to arrest. This is in your own evidence. In their own evidence, they said, in the video evidence, it shows that at no point did they ask for his name and address. There was no, they wasn't even thinking about writing him out summons. They just wanted to nick him. And they did. This applies to Section 5, the lowest category of summary offence. Summary offences can be, as this is, summons only. This was, in effect, an unlawful arrest, detention and prosecution. Because if the arrest starts and it's unlawfully, then the prosecution that follows is unlawful. Again, I'll go into the law, and these are judges' words. These are not mine, where it's quoted what the judges actually said. These are the cases that I put up there, 1, 2 and 3 is the primary. This is really all the law, and there's much of it that I went and researched and found and put it in there. No one else would have done that. No solicitor, no barrister, they're lazy. I just think, oh, just get a conviction, pay the fine, even if it's unlawful, even though you're being prosecuted and you shouldn't be prosecuted. So what we did there was we actually said the weekly law reports, Dictator of Law Bingham of Cornwall in Director of Public Prosecutions versus Collins in 2016, that a further court asked to convict a defendant of an offence under Section 12723 on the Act on the basis of the content of something they had said or written, was obliged to ask itself whether such a conviction would constitute an unjustified breach of the defendant's right to freedom of expression, guaranteed by Article 10 of the Convention for the Protection of Human Rights and Fundamental Freedoms. That, in the present case, although the prosecution pursued a legitimate aim, namely the protection of the complainant from persistent and unacceptable offence, this wasn't the case in this, it wasn't persistent, wasn't unacceptable, but the prosecution could not, on the facts of the case, be justified as necessary in a democratic society for the purposes of Article 10.2 of the Convention, that rather, a prosecution and conviction of the defendant would represent a grossly disproportionate and entirely unjustified interference with her right to freedom of expression, and that accordingly the defendant's conviction would be quashed. Post paragraph 33, emphasis added. There is so much of this. There is another big one here. This appeal illustrates the need for decision makers in, this is a separate case, for criminal justice to have regard in the cases where they arrive to issues of freedom of speech. In that context, I add by way of footnote reading the judgment of Nick J. Hayden versus Dickerson, which Warby J. cited. I was surprised to read at paragraph 39, the defendant, this is someone, so this judge is actually saying, if other cases come up like this, I'd bring them on and we'll side with the defendant. They're telling the lower courts, if you carry on with these types of prosecutions, put it in front of me. So some judges are with us. We just got to find them judges. So Blackwell emphasises the higher court's comments. This appeal illustrates the need for decision makers in the criminal justice system to have regard, in cases where they arise, to issues of freedom of speech, submissions, and the questions of law. Was Blackwell unlawfully arrested and detained because the police did not have the authority to arrest? This is a statutory summons-only offence, not a common law offence with a power of arrest. Page 5. If A above is yes, this is an abuse of process and can unlawful prosecution. It should not continue. What does that mean? When this got put in front of the magistrate and the new CPS geezer read the document, they stayed the proceedings. They don't like using that term, but that's what happened. A stay means this is an unlawful prosecution, get it out of this court, and 3 police officers stood there red-faced and then scurried out of the court because they had made an illegal arrest. Test applied, right? They also, in relation to this case, so there's many things that I've put on there as well. Has Blackwell rights under Section 3 of the Human Rights Act and Article 10, Article 14 of the issue of discrimination? Has it been considered? And it obviously hasn't. They've literally run a mile from this defence. The last part of this is really important. The clear guidance of the CPS is that civil proceedings, a summons, that's what a summons is, basically, a civil proceeding. It's not, they class it as criminal, but it's sort of, they're telling you to behave yourself. Should be used, not the criminal justice system at first instance. In this case, even a civil procedure would have been deemed excessive. Blackwell has been criminalised for exercising his convention and constitutional statutory right, a fundamental right, freedom of expression, and has unlawfully been referred to as far right by the prosecution for having an opinion on illegal immigration. This brings state bias into the prosecution. The police should not be used as government policy enforcers, nor should the CPS or the police act as though they are referring to him or the protest as far right. The defence of reasonableness. Blackwell by law has the English Convention Parliament's constitutional statutory right via the English Bill of Rights of 1688. The more people use this, the more it's going to come up in cases. Enacted the freedom of expression, the common law right and customary right of freedom of thought, expression, and importantly the freedom to petition, make a demand, without prosecution for such petitioning or the use of commitments against him. This right is an incorporeal right. These rights were the seed of the European Convention on Human Rights, Article 14 and Article 10. That is true. So the English Bill of Rights was the seed of the European Convention on Human Rights. And people need to understand where them rights come from. Like when I went to America and spoke to the Texans, where does your constitution come from? It comes from England. It is unreasonable to infer that a common expletive or descriptor in common use has caused harassment, alarm or distress in this case. Blackwell, by law, has the international human right to freedom of political belief and to have the law of the land enforce law reports, right? So I'm telling them, go look at the law reports. He has a right to have the law enforced, and that includes that any of them people that are known to have got rid of their documentation and lied about where they're from because they are economic migrants are committing the offence of perverting the course of justice, a serious criminal offence in this country. It's as simple as that. They don't like the fact that this has gone in. We said take it as a report. Perverting the course of justice is an offence, and many immigrants are committing that offence. Do you all agree with that? You're the members of the public. Look, you're the jury on this. You're the ones on the, as Lord Denning once said, you're on the omnibus. This is being explained to you. Do you agree that someone has got the right to turn around and say, hang on a minute, you're putting these people in housing when we've got people dying on the streets, freezing cold, our own veterans on the streets, our own elderly on the streets, and you're putting these people up in hotels with our tax money, and they've lied about where they're coming from. They've thrown away their documentation, and you expect us to keep our mouth shut? It ain't happening. And then what do the police do? They go out and they policy enforce. That is illegal. It's not the law of the land. We're telling them what the law of the land is, and them people are criminals. Summary conclusions. Proportionality. The common law and convention has provided that the prosecution of this offence must be proportionate response to the conduct complained. If anything, Blackwell has been shown to be vulnerable to the abuse of power and privilege that the police and the CPS hold as state officials, and they have politicised these courts. This is evidenced by the term far right being used and the enforcement process being used, one, to cause severe pain during and after arrest and during custody and the length of custody. Two, suffering an abusive process but via a prosecution. This is contrary to Section 134 of the Criminal Justice Act 1988. I wonder if they looked it up. Blackwell's rights of freedom of expression, and there it is, supported by Graham Moore, Mackenzie Friend. You will see that they also awarded costs to English Bulldog. So claim costs under magistrates research law, case preparation and defence case statement, £1,950. 10 hours at 10.8 hours at £180 an hour. And that just gives the whole lot of them an education in the law. Do you think that's reasonable? Because I do. The magistrate did, because they okayed it. So, what I'm showing you is the amount of work that a genuine, decent, honourable, law-abiding person, without having any attachment to any of these political biases, but a constitutionalist, puts a case towards the courts and says, that's the law of the land. It's as simple as that. Do you know any other solicitors and barristers that would do that? Do you know anyone that would literally stick their nut into a case, read through all the paperwork, convey and speak to the person and say, listen, this is what you got to do. We'll write it out. Let's get it out. Don't plead guilty. This is all bullshit. And in the end, they had to agree because they had committed the offence, not him. Because when you arrest someone and you have not got authority, you are committing an assault, a battery upon that person. That's what's happening. And then they deprived him of his liberty, which he'll never get back. 48 hours in a prison cell, in a police prison cell, in pain. That's what them people did. All because they didn't like his opinion, and they refer to that opinion, your opinion, people, as far right. When people are committing criminal offences and stealing the housing of the people that have paid for it for years. That's your police for you. They are policy enforcers. And that Parliament is the Politburo, and them courts are part of that system. And that is what we're here to stop.